'Cause you can't, you won't, and you don't stop. Or when you can't, you won't, and you don't stop. Might be coming down for sure.
Just because an agent has these duties doesn't mean they can't get anything out of the deal. There are two key things that the agent gets. The first one is a really interesting one, which is indemnity. Now, what does that mean? Well, it means that the agent is acting for the principal, so they're indemnified by the principal, or the principal has to pay for what the agent does, right? So when we have that contract, right, even though the agent might be the one physically signing the contract for the principal indemnifies them so that the agent isn't contractually bound under the contract. They'd also be indemnified for things like reasonable costs, right, and maybe negligence that arises as part of the action that goes on through vicarious liability. But we have this general indemnity. So when you're employed, right, when you're employed by someone, you end up being indemnified. So you may not get sued if you do something wrong at work or you enter the wrong contract because you're indemnified by the principal or the employer. The second thing that you're entitled to is remuneration, and that should go without saying. Normally, it's also part of the agency agreement. And it can actually be structured in many ways, flat fee, commission, etc., or like when you're employed as a salary. The other main situation that we want to be able to think about in terms of agency is when the agent might actually be liable. Okay, so are there any situations where the principal kind of can get out of the contract that the agent might have entered into, and or when the agent might have to pay for a mistake that they actually made? That's an example of what we're trying to talk about. Okay, so when might the agent actually be liable? Remember that a key defining feature of the agency relationship is that the agent generally isn't liable, right? That's the whole point for having this special legal relationship in business. However, there are three specific circumstances where the agent may actually be liable. First, where they're intentionally liable. Okay, so sometimes the agent might want to be liable. They might enter a contract specifically being liable for what they do. Okay, then they can be liable. The second time is when there's a breach of warranty of authority. They're fancy words for saying what happens when they go beyond their authority. Well, they can be liable, but they're liable back to the principal, not to the third party for the contract. Okay, we'll come to that, but that's a breach of warranty of authority. And the third time an agent might be liable if there's an undisclosed principal. So what's that all about? Well, imagine that my son, for instance, appoints me as his agent, and I go into Ferrari to buy a Ferrari, and I walk in as Gavin Nicholson with whatever's in my bank account, etc. And Ferrari look at my bank account and go, yeah, that's fantastic, you can buy one. And I sign on the dotted line and buy a Ferrari, and then after I finish signing it, they want to get the money off me, and I say, oh, no, I'm acting as an agent for my son. Right, you got to get the money off my son. The contract is with my son, not with me. I'm just the agent. Can you see the problem there? Ferrari, who's the third party, they only think they've been dealing with me. They don't know anything about the principal, about my son in this relationship. Okay, so that is a case of an undisclosed principal. So in fact, the agent can be liable in cases of an undisclosed principal. Let's look at these in a bit more detail. When might an agent be liable? Well, the first case is where the facts show that that's what the parties intended, where there's intentional liability. Can be rare, but it can arise explicitly or via inference or custom or standard. Most of the time, we're going to want to see it explicitly in business. The second kind that we're dealing with is this idea of the undisclosed principal. When an agent acts for a principal, but they don't tell the third party, right? That's because the third party believes they're contracting with the agent alone, not with the principal. In that case, the third party can choose to enforce the contract against either the principal or the agent. Now the question is why? Why choose? Well, because they might have thought that the agent had the money. That's who they looked at. So in that case, they can enforce against the agent. But they were really acting for the principal, so they can enforce that contract as well, right? So it's at the behest of the third party as to who the contract is going to be enforced against. Now, the final unusual thing about an undisclosed principal is, what do we do about the rights of the principal, right? If there's a contract that's been signed or entered into by in an undisclosed principal situation, so the agent has entered into a contract with the third party, not telling them about the principal, can the principal enforce the contract, right? This situation deals with whether the third party can enforce the contract, and they can against either the agent or the principal. But what can the principal do? Normally, they can enforce the contract against the third party unless, so there's a certain situation where the principal won't be able to enforce the contract. Okay, when would that be? When the agent did not have authority, the agent actually told the third party they were not an agent, and the existence of an undisclosed principal is inconsistent with the contract. Super important here. Or test. Okay, so the principal can't enforce it if the agent never had authority. They can't enforce it if the agent told the third party they weren't an agent, right? Because again, that's a kind of fraud. In the third case, it's where that the identity of the person who you're contracting with is really important to the formation of the contract. And I'd really suggest you have a look at said and but, our case here. And here we have a case where the identity of who the contract was important. And they'd used an agent to kind of get around that particular problem here. So in that case, the principal couldn't enforce it because of rule number 3. The final element is the more clear-cut case where an agent goes beyond their warrant of authority, what's called the warrant of authority, or their scope of authority. In that case, the third party can also claim against the agent, right? Because to some degree, the agent has misrepresented the particular situation, and so they're liable for that misrepresentation. It's not really misrepresentation, but that's a way to think about it. So what are the 3 elements that we need for a breach of warranty of authority? Well, first, the agent must claim that they are making the contract on behalf of the principal, right? So they've got to say we're acting for the principal. And the agent must not have the authority, because if they had the authority, then the normal agency relationship would take place. So we're now in a situation where the agent has overclaimed their authority, okay? And then if the third party relies upon what the agent says and wouldn't have entered into the contract without that, then the agent becomes liable. Can be a little bit complex. Most of the time, the agent is not liable. They can be liable if they intentionally want to be liable. They can be liable sometimes if there's an undisclosed principal because the third party doesn't know about the true principal. And finally, they can be liable if they go beyond their scope of authority for a breach of warranty of authority. But in each of those last 2 cases, you want to look and make sure the elements of the specific test are met in order to show that specific liability arising. The final thing we're going to look at is how do we terminate an agency relationship. We're not going to spend a lot of time or go into a great deal of detail here, but it's like most contracts into how it can terminate. It can terminate when the agent actually does what's asked of them. Okay, if you've done what's asked of you, then the agency relationship comes to an end. You might specify a duration for the appointment. Okay, if that's over, the agency relationship ends. There could be an agreement to terminate between the principal and the agent. The principal could sack the agent because they've maybe breached the contract or breached the duties. And the principal can also revoke or limit the authority of the agent to act on their behalf. Okay, so there's a number of ways that the agency relationship can terminate. One of the important considerations is if you ever enter an agency relationship, whether you should put a duration on there so that you will have a definitive end date to it in case, circumstances mean that you never really rethink about it and absolutely end it. If you have a date there, it'll end at that date. That's why there's one of these recommendations that as part of an agency relationship, you put a duration of the agency relationship in any agreement. Well, that's a whole lot of stuff about agency. In the next little video, we're going to look at moving beyond, say, contractual relationships and contractual liability under the agency relationship into vicarious liability, which is where you can be liable for the conduct of others, for instance, in, say, negligence rather than contract law.